Taking Effective Expert Depositions is an approved continuing legal education program that I presented to a major California law firm in February 2024. Both lawyers and experts should avail themselves of this invaluable information. It will help both groups better represent their clients in sophisticated litigation matters. When I talk about taking effective expert depositions, I don't presume to tell lawyers how to practice law. I am admitted to the bar. I have technically never practiced law. But what I want to do is share my perspective with you from my side of the desk, the expert witness side of the desk. And given your level of experience, most of my comments today about depositions will be a review of the obvious for you. But please keep an open mind that there might be 2 or 3 tidbits that you might be able to pick up to help you better do your jobs representing your clients. I have been deposed about 600 times in the last 40 years. And I think I know when the lawyer has done a good job and when the lawyer has done a bad job. If the lawyer has done a really good job, though, I don't know it. And today, what I want to share with you are some of the techniques that I've observed as an experienced expert witness to help you be the one who does a very good job taking your next expert deposition so you can better represent your clients. So today I'm going to break my discussion into 4 sections. 1 is advanced preparation for the deposition. 2 is immediate preparation for the deposition. 3 is tactics during the deposition, and by during, I'll break that into 3 subpoints: at the beginning of the depo, during the depo, and the cleanup at the end of the deposition. And then we'll close with a summary of what I've talked about. Let me start with my section 1, advanced preparation for the deposition. So, are you posturing for settlement or are you posturing for trial? This affects your strategy. Posturing for trial, you're going to be more closed in your examining the witness. Posturing for settlement, you're much more open to unloading on the witness, showing your best arguments through your questions. There's no need, and by the way, none of the things I say are absolutely black and white. There, of course, are considerations that you may say, well, what about this or what about that? I certainly understand that. But generally speaking, if you're posturing for settlement, there's less need to hold back anything. You can consider winning the deposition through your questions. Now, I tell experts when I talk to them about how to give an effective deposition that as an expert, you can only lose in a deposition. Theoretically, as a lawyer, you can only win. But I want to suggest that there are some ways that lawyers can lose in a deposition. And if you're going to trial, in my opinion, you need to be very aware of the possibility that you can lose at the depo. Maybe not completely, but you can lose with respect to this particular expert witness. In a couple minutes, I'll talk about what I call the two-way street aspect of depositions that many less experienced experts, less experienced lawyers miss, the two-way street aspect. So again, advanced preparation, posturing for settlement or trial. Next, don't fear your lack of substantive knowledge in the expert's area. It's the expert's deposition, not yours. In my experience, the best depositions of me are taken by the unknowledgeable lawyer. I like to refer to the Detective Columbo. Interestingly, if you're nodding your head, you're dating yourself, because when I use the Detective Columbo example in my law school classes, I look out at this blank stare because those kids don't know who Detective Columbo is. But I see some heads nodding. So I think the Detective Columbo approach is the best approach to taking an effective expert deposition. The seemingly dumb guy who's just trying to understand what I did, but who's really the smartest guy in the room, guy or gal. And the worst depositions of me, I'm a financial expert, are taken by the young, hard-charging MBA or CPA lawyer who wants to get into the technical details of what I did. Discount rates, capitalization rates, build-up methods for how you determine a capitalization rate, those kinds of things. Now, doing that might not hurt, I don't really know, but it's usually too in the weeds to be effective later on. So if you want to spend your time really grilling, if you're a biomechanical engineer in your undergraduate degree or whatever, and you want to spend time talking to the biomechanical expert about that, knock yourself out. I don't think it really hurts, but I'm not sure it does that great. Still in advanced preparation, consider a video deposition. I know they're expensive, but in a video deposition, the expert has to bare his or her soul, versus a regular deposition where the expert has the opportunity to be much more glib or cagey with his opinions. So the video deposition, I hate video depositions. So do them if you can possibly do them. And finally, interesting strategy here, consider not even taking the deposition of the expert witness. If you have a complete report done by the expert, or your expert has had the opportunity to thoroughly review the opposing expert's file, and you're comfortable knowing everything you need to know, including some errors or weak spots in the expert's analysis, you might be better off holding your cards and not taking the expert deposition at all. If you look at this from the other side of the desk, my side of the desk, the best preparation you can give me for trial is noticing and taking my deposition. Because I'm a little bit like everybody else. If you don't hit me over the head and tell me there's a midterm, I'm probably pushing it to the other side of my desk, et cetera, et cetera. But knowing that my deposition is coming up on, what's today? Wednesday, on Friday, that really makes me prepare. Kind of the midterm examination. And you definitely scare me when you take my deposition. I get a sense of how good you are, how strong my position is or isn't. And if no deposition, I am not going to be as prepared for trial. So, again, a lot of considerations here. I don't mean to tell you how to do this, but if you can possibly justify not taking the deposition, if you're really comfortable, give it some consideration. This will tie into holding some things back for trial, the two-way street aspect of taking depositions. Anyway, I'll get into that in a second. Now, this is a big point and probably below most of your pay grades, but a deposition is a two-way street. Be mindful of this reality. In my opinion, there's a real art to taking a deposition and not giving away some of your strategies. Think about that. You're either giving them away explicitly or implicitly. And most lawyers just can't not argue. They just can't do it. You find this weak spot in my analysis and you just can't dig in. Let me beat the crap out of this guy on this weak spot. Well, let me ask you, what are you doing at 9 o'clock at night, the night before you're going to cross-examine me at trial? What are you doing at 9 o'clock at night the night before? You're doing the exact same thing that I'm doing, which is sitting at my house. You're not sitting at my house, but I'm sitting at my house, reading my deposition that you took 2 or 3 months ago, and you're sitting at your house reading the deposition of me that you took 2 or 3 months ago. I can't think about it. If you just couldn't not argue, like most lawyers, and you hammered me on a few soft spots in my deposition, in my analysis. And by the way, I know none of your legal positions ever have any soft spots, none. But a few of my economic positions do, you might be surprised to learn. If you hammered me on a soft spot on page 49 or page 56 or 87, what am I doing? I'm sitting there, aha, he's onto that. I'm going to spend the next 12 hours in my head trying to finesse my way around that soft spot that you clued me into knowing that you saw. On the other hand, if you're Detective Columbo, maybe you let me think that I blew that soft spot by you, and it's unimportant to me. Yeah, he didn't get me on that thing that doesn't agree with some other thing or whatever, and you're holding back for trial. So don't be the person who can't not argue. Be incredibly passive in the deposition, cross-examining the expert in cases that are going to trial. If you aren't, it will not serve you well. So next, a good deposition, still on the advanced prep, just thinking about these things. A good deposition gets to the core of the issues that the expert has analyzed. The lawyer's job is to get the expert to state the opinion and the analysis in basic terms. Think of it like a law school outline. They were Gilbert's outlines in my days. Are they still Gilbert's outlines, or are they other? Yeah, there are other kinds of outlines. I don't even know the brand names anymore. But your job is to force the expert to present his or her opinion in an organized, understandable manner. The lawyer creates the blank outline. Roman numeral 1, A, B, little I, 2 little I, 3 little I, Roman numeral 2, etc. That's your job, to create the blank outline and make the expert fill it in. No big deal. You guys should all generally understand that. But the lawyer's preparation in advanced prep should include, and I don't need to tell you this, but let me just tick these things off, a discussion with your own expert about the anticipated analysis and opinions of the opposing expert and the reputation of the opposing expert, inquiry of your law firm colleagues about previous opposition or retention of this expert, performing some research in the substantive area, shameless plug, some research in the substantive area, lost profits or finance and accounting for lawyers. These kinds of books are out there and you should consider them. And so some research in the substantive area. If you have them, and I know you guys have this, review some transcripts of the opposing expert so you can find out if he or she's smart, stupid, a jerk, or not a jerk. Someone was telling me that AI now allows lawyers to literally search while a witness is on the stand, and I think this is a big deal for these national economic experts who are testifying all over the country, and many of them saying, 2 and 2 is 11 in the Ninth Circuit, and 2 plus 2 is 4 in the Third Circuit, and 2 plus 2 is 7.5 in the Fourth Circuit. Some of these national experts are doing this. I understand, or I've been told, that now lawyers can search this literally online, real time, in some of these opinions that these people are giving and find out if there are contradictory opinions. Thank goodness I am getting out of this business, and I don't think I have too many flaws out there, but I'm sure you could find some. Now, of course, nowadays you get the expert's file ahead of time. We absolutely hate that. Back in the day, I used to be able to show up at a deposition, and I don't know how many years ago that code section came in where we have to produce the file 3 days ahead. But back in the day, I used to show up at a deposition and stack down 4 binders in front of poor Mr. Silver here and say, okay, ask me any questions you want to ask me. Now, of course, you get my file 3 days ahead of time and you get to look through it or have your expert look through it. And that fact really changes the playing field for me. But let me give you a little unimportant tip. Even if you don't go through the file, take the file and put a bunch of little Post-its on it and have them sitting there when I walk into the deposition, because it's very intimidating. If I sit across the table and look at you with a bunch of Post-its on your file, I'm like, oh man, this is going to be a tough day. So those are my thoughts on advanced preparation. I'm going to ask you in a second, but to summarize them, conceptually, are you posturing for trial or settlement? Don't fear your lack of substantive knowledge. It's not your depo, it's mine or the expert's depo. Consider the video. Consider not even taking the deposition if the facts are shaking out for you that way, because you are showing your hand when you take the deposition, and you're making me prepare in a way that I might not otherwise prepare. I'll talk in a minute. We all know how busy many people are. Your job is to create the law school outline and make the expert fill in the blanks on the outline. Let me move to what I'm going to call immediate deposition preparation, or also known as the morning of. So, recognize, this is all my opinion, of course, recognize that you have a narrow window of opportunity to gain whatever psychological advantage you can gain over this particular expert. You are in control as the deposing attorney. Don't give up any of that control. For instance, and a lot of young lawyers will do this, in the casual chit-chat before the deposition, the lawyer will, the rule is don't share any of your insecurities. There's no reason to be nice to me and say, oh gosh, I don't know anything about finance. Or, gee, I've never taken an economist deposition before. It's very polite, very nice. Why give me that? Many times the opposing lawyer will, especially the younger ones, will give away that sort of insecurity. Don't do that. Just keep it professional. Keep the witness in the dark, politely. You don't have to be a jerk, but there's no reason to give me that little tiny victory. And here's a similar minor point. Don't tell me, it's 10 minutes to 9 and the depo starts at 9. Don't tell me that this will only be an hour. Why bother? What good does that do? What do you gain by telling me that? I don't know. Well, you can't. I don't think you're allowed to keep me for 3 days. But I don't know how long we're going to be. It just gives the expert something to ease the anxiety with. Don't do it. You're in control. Be mindful of the fact that you're in control and hold back on that control. Like I said, you don't have to be a jerk, but there's no reason to give that out. Okay, let's move into the actual deposition, and my first sub-point is the beginning of the deposition category. So reminding you again, and this is really big for me, you have a narrow window of opportunity to gain some advantage over the expert. Don't give this strategy away. Now, my preface to this point, and again, having you remember, move over to my side of the desk strategically to think about where I'm coming from. Everybody's busy. We're all scrambling around. To the expert deposition is like trial for you in your office. The expert is running around, has a deadline at 9 o'clock. I'm reviewing, I'm reconciling this problem and that problem. I'm covering weak spots. I'm hopefully not rude and yelling at staff people, but I'm saying, what the heck did you do here? Why do we have this? Why are we doing this? We're trying to get everything done, and it's, I'm sure your office is all organized and you don't ever have any scrambling just before trial. Right, Okay, but I do in my office. And for me, it's more, ironically, before depo than before trial, because as I said before, the depo's like the midterm exam. Once I've done the depo, a month later, I pick it up and I read the depo and I'm pretty ready to go. But it's the depo where I pull it all together. So now we're in the depo, and this background concept brings me to sequencing. Sequencing your questions at the outset of the deposition is, in my opinion, critically important. At the start of the depo, right at the start of the depo, only ask a couple of formality type questions. Now again, this is from the perspective of an experienced expert witness. We may vary this theme a lot, certainly for the lay witness, and maybe for the less experienced expert. But I'm suggesting, if you're looking across the desk at somebody who's done this 100 times, ask the expert, have you had your deposition taken before? You've had your deposition taken before, right? Are you finished with your work? Please list your opinions. When that happens to me, it's like, damn, this is going to be a serious deposition. Please list your opinions. Please list every opinion you are going to render at trial. Are there any more? Is that all? You know how to ask the questions. I don't know how to ask the questions. But don't give the expert a few minutes or 10 minutes or 20 minutes at the beginning of the deposition to relax and size up the situation. Put him or her on the spot right away. Okay, now, this subpoints of this. Admonitions. For the experienced expert witness, the admonitions are a complete waste of time, in my opinion. I have testified in 300 trials, and I have never been asked, Mr. Brennig, you said you were aware that the court reporter was sitting on your right-hand side and taking down everything you said, and you said you were, right? Or you were told you were under penalty of perjury, right? In 300 trials, I have never been asked or read back an admonition question. So, if a lawyer is giving me admonitions, I sit there and do nothing while the lawyer talks. I'm looking around, oh boy, this is a big conference room. I wonder what your partner meetings look like here. I wonder where Mr. Silver gets to sit at the partner meeting. Is he at the head, or is he at the, in the back room, or is he getting the coffee? I'm doing nothing. And you're just wasting time. Or the other thing that I'm doing is I'm saying, damn, I found this problem at 7 o'clock this morning on page 84 of my file, and it doesn't agree with what's on page 46 of my file. How am I going to finesse that if ever he or she gets around to ask me that? So I certainly understand that admonitions may be beneficial to you, or maybe you have to do them for a lay witness and or a less experienced expert. But I would certainly say for an experienced witness, they are an absolute waste of time and strategy. Okay? That's admonitions. Now, background, education, and experience. It's a little more complicated than admonitions, but it falls kind of sort of in the same category in my view. If this inquiry is even necessary, it shouldn't be made at the beginning of the deposition. Why? I've been testifying as an expert witness for 40 years. Do you think I cannot summarize every aspect of my resume without thinking? I mean, I could talk about myself for an hour and be entertained and not be bored. So why ask me? So 2 questions. One is, why even ask me that? We'll talk about that in a second. But secondly, if you're going to ask me that, don't do it at the beginning of the deposition during this invaluable strategic time where you sit there and ask me where I went to college, and I watch you stumble around while I relax and get comfortable talking about nothing that is difficult for me to talk about, and thinking about how am I going to deal with that problem on page 84 of my file and compare that to what we said on page 50 of my file. I got a problem there, and I got to figure out how to get around that. Now, should you even do background education and experience? If you anticipate that the deposition might be used at trial in lieu of testimony, why should you qualify the opposing expert? I mean, there may be more things to consider there that I don't understand about the practice of law, but why should you qualify the opposing expert? And the other thing I think about is there are, of course, some cases where this particular expert is stretching his area of expertise and shouldn't be doing it. And you may want to cross-examine the expert on that. And the example I think of that I use from time to time is, okay, I do a lot of business valuations. And let me put this in context. You guys are big-time good lawyers. I have this categorization of lawyers in my head that the top 20% are good lawyers, the bottom 20% aren't even worth talking about, and the middle, I think it's 40 and 20 or 60, whatever it is, 60%, 62, yeah. The middle 60% are, yeah, I'm an accountant in my spare time. The middle 60% are average lawyers. Working as an expert witness, I get to see, hopefully I almost never see the bottom 20%, but I get to see a lot of the middle 60%, and they want an expert to do things like, hey, Brian, we only want to hire one financial expert, so we need you to do, in addition to the business valuation, we've got this issue over here about the demographics of the area or the traffic counts or something like that. And the way I say it, if I'm talking to other forensic accountants, I say, if there's some little tiny throwaway that you can scoop into your business valuation, for example, that, oh yeah, the traffic counts in this neighborhood have gone up in the last few years or gone down in the last few years. That's probably not too much of a stretch. But if traffic counts are a big deal in this particular case, I say to the forensic accountants, you better not be talking about traffic counts, or you're going to find out very quickly how little you know about traffic counts. So if you think I'm going to hammer this expert, this accountant, for instance, on traffic counts because he or she has no business talking about them, the question becomes, should you do that at depo or should you do that at trial? And I think all I am encouraging you to do is consider that, because if you do it at depo, I'm going to be reading all kinds of little chat GPT things on traffic counts, and I'm going to sound like an expert by the time I get to trial because you clued me in. You told me at my depo that you found a weak spot where you could have completely, faked me out at trial by bringing up something that I thought I was just going to walk away with. So those are my comments on background education and experience. And at the beginning, for the first part of the depo, to kind of summarize that, there's a narrow window to gain advantage. Don't miss that opportunity. Sequencing is critically important. Admonitions are a waste, and background education and experience, decide whether or not you need it. And if you do, don't do it at the beginning. You might as well do it at the end when we're both falling asleep and I can tick off my background education and experience there. So during the deposition, now we already were at the beginning of the deposition, now we're during the deposition. Number one, I'll number these for you. Attitude and demeanor. I certainly understand there's judgment here. A less experienced witness may be somewhat intimidated by an aggressive approach. And there are certainly many situations where I think you're using an aggressive approach is probably beneficial outside of my area of expertise or even commenting on. And maybe I'm tainted by my own perspective, but my perspective is that a cool, calm, and collected approach is probably more effective with an experienced expert witness. The chance is, at least from my perspective, the nice guy or gal is going to get a lot more out of me than the obnoxious antagonist. You know, the LA law thing does not work very well for me. As soon as the other person presents himself as a jerk, I feel like I'm experienced enough to kind of just shut down and say, okay, dude, you want to play this game? I can play this game. That's just fine. So I really think cool, calm, and collected is the way to get the most information out of me. I'm just here to do a job. I try to do my best not to have a big axe to grind one way or another. You know, you ask me the questions, I'm going to give you the answers. Here's the analysis that I did. Here it is. So that's what I think about attitude and demeanor. I'm sure there are many situations when you guys need to use the more intimidating demeanor, and I'm kind of backing up in the talk thinking about, you know, the admonitions, you know, there's the court reporter taking this down and you're going to have the opportunity to review it and everything, you know, all that stuff, and creating that somewhat intimidating environment, because appreciate how intimidating the whole deposition process is. And we all experience this. If ever you talk to a lay person who's got their deposition scheduled in some case, they are freaked. I mean, it's like, oh my God. When I was very active, I would have, 3 a month, 35 depositions in a year. Or sometimes I would go to a conference and talk to other forensic accountants and say, well, could we do this in July? Oh no, I've got a deposition in July scheduled. I got 4 depositions in July scheduled, or probably 6. Not now, thankfully. I probably have 6 scheduled, and I know that 2 or 3 of them are going to go away. I mean, this is going back 5 to 10 years. So anyway, but the deposition is very, very intimidating. Of course, you're mindful of that, but I particularly think that a cool, calm, collected approach is better. Administrative, next point. Near the outset of the deposition, but not right at the beginning, I've already said what I think you should do then, review the deposition subpoena with the witness and ask the witness to confirm that they brought everything. Invariably, and I'm talking about when I was really busy, the experienced expert who's got 50 or 75 cases going, I looked at the deposition subpoena last night and you asked me for 14 things and damn, I don't have number 11 and number 13. Not because I'm trying to hide it from you, because you're going to get it, but I just don't have it. It's kind of embarrassing. Oh, did you not bring it? Oh, didn't you see it? Did you read it? I mean, you can make me feel a little bit bad on that stuff. Here's a good one. Ask the witness to describe everything in his file. You ask me that, and I say, well, the index is right there. Don't let me blow you off. No, please just go through and describe everything in your file. Do you want every page? No, not every page, but every category. Okay, why is that good? You sit back and do nothing, and I'm sitting there going through the entire file. You might find a document that you didn't know existed. You might ask me, what did I use this document for? I might find a document that I just glanced at that was really important. In other words, it just shifts the burden, and you're sitting there doing nothing, making me work. I think that's a good thing to think about doing. What documents didn't you bring and why? Were you told not to bring them? Were you asked to remove anything from your file? Oh, really? Spend a little time on that. You guys know how to ask the questions, but that's, good turning that rock over. Inquire about billing to date, and I particularly like two aspects of the billing. And this is embarrassing for me. You see, I can only do this late in my career. But how much of the work I did versus how much of the work Alejandro did. And sometimes you look at some of these cases and man, in my case, for a simple personal economic loss analysis, it gets to be, 90% staff and 10% me. Well, that's just a little embarrassing. And the other thing is review the billing categories. Now, in my firm, I'll talk about one of my partners namelessly. He has a practice. The only billing category he has is economic analysis. That's it. But you get a less experience. I have 3 or 4, but they're all pretty generic like that. You get a less experienced expert, and they've got, talk to Mr. Silver about this, and I told him I thought that was a terrible argument. You might find some really good stuff looking at those categories. Okay, next, mechanics of taking the deposition. Don't be obsessive about pre-planned questions. Much more is learned by sitting back and listening and thinking, okay? Going with the flow of the answers. But when you're dealing with the substance of the expert's analysis, ask for each step of logic taken by the expert in developing each particular opinion. For each opinion, for instance, a question like this: give me a broad overview of the steps you have taken to arrive at opinion number 3. Chronologically, in order of importance, any way you want to get the expert to say it. Again, you create the Gilbert's outline and make the expert fill it in. And then, once the expert's analysis is reduced to 5 or 6 major steps of logic, each step should be examined methodically. So with respect to each step, you're going to ask these kinds of questions. Now, you are the experts at asking questions, not me, but let me try. Why is this particular step necessary at all? Could the step have been eliminated? Has the expert performed this type of analysis in the past without including this step? What was the specific outcome of this step? On what facts was the outcome based? What observations was the outcome based? What assumptions, what judgments was the outcome based? Generally, what other outcomes are possible for this step in an analysis? What facts would cause a different outcome, higher, lower, weaker, stronger, at this step of the analysis? And if the expert opines to some inadequacy, what in his or her opinion would constitute adequacy? If the expert opines to some failure, what would constitute success? What is the range of reasonable outcomes of this step? I'm a finance guy, so I think of numbers. If the lost profits are 50,000, what's the range of reasonableness? 40,000 to 60,000? Or is it 0 to 10 million? Tell me what the range of reasonableness is, Brennig. If somebody was within plus or minus 10% of where you are, would you say that's unreasonable? These are the kinds of questions where you're making the expert argue with himself. You're making the expert give you alternative facts. I guess that's a technical word now that we can use. Get the expert to give you alternative facts that would change the opinion. And of course, when it's time to go to trial, you're going to focus on these alternative facts that cause the opinion to go your way. So this make the expert argue with himself is a very effective technique. Some of these things I'm sure you know. Follow through on equivocal answers. If X is generally true, when would it not be generally true? Answer true based on what I know now. What would you need to know to make it unequivocally true? Follow through on highly technical or rambling answers. Don't be intimidated by your perceived lack of knowledge. You are being BS'd if an expert gives you a long, bloviating answer. The most effective thing in a trial for impeachment is a short, crisp answer that serves your side of the argument well. Don't think that you can effectively use a long, rambling answer in impeachment. As soon as you, and what I tell when I'm talking to experts and telling them how to give an effective deposition, I'm saying, if the lawyer boxes you in right down real tightly, do your best to put a bunch of junk in the answer. Because, well, you know, Mr. Silver, I understand what you're saying, but you don't understand. It's this and it's that, and it's this and that. But if it was this, then maybe it would be a yeah. Now, your skills are taking that bloviating garbage and reducing it and reducing it and reducing it down and getting it down to a one-phrase question with a yes or no answer that goes your way. That you can use as effective impeachment cross-examination at trial. But you can't use, well, let's look at page 68 of Mr. Brennig's deposition. Here I asked you if you met with the controller, and let me read it. Did you meet with the controller, Mr. Brennig? Well, I was able to meet with the chief financial officer and the chief operating officer, who told me that the controller was on vacation for that week and it really wouldn't be important for me to meet with the controller. So I dealt with the CFO and the COO and got the answers that I needed. Nobody listens to that. Did you meet with the controller? No. That's a good impeachment answer if that's what you're trying to get to. So your job is to narrow the question, to get it down to a one-word answer. Everybody knows that communications with others by an expert are not privileged. It is amazing how many lawyers, and of course clients, either don't know that fact or forget it. There's actually lawyers in the lowest 20% and in the middle 60% who sort of think, oh no, that was privileged. It's not privileged. Nothing a lawyer says to an expert, unless it's a consulting expert, not designated, but nothing that a lawyer says to his or her expert is privileged. So ask the expert to name every person with whom the expert has communicated, the reason, the nature of, when it was, etc. You should be asked about every meeting. The expert should be asked about every meeting that you had. Were any documents given to the lawyer or the client during that meeting? I feel like if an expert gave some documents, the expert better have a copy of the documents. It's one thing to have you come to my office and we'll look at this together and you tell me this, that, and the other thing. And 3 months later I can say, well, yeah, I showed him this draft, this very preliminary draft, and he had a few comments. And honestly, I'll tell you a quick side story in a second. I don't remember what the comments were. Okay, quick side story. Some of you, the guys and gals my age, will remember this. Remember Art Broadschatzer, the grand old man of forensic accounting expert witnesses? I was about 35 when Art was about 65, and I can remember sitting across the table in a deposition, and lawyer says to Art, what happened in that meeting 2 months ago? And he says, and Art was a real tough customer. He never liked people who were against him. He was always a kind of a tough deal. He says, what happened in that meeting of 2 months ago? I don't remember, counsel. I don't remember. And I'm sitting over there saying to myself, you lying SOB. And then I got to be 60. And I remember if you asked me what happened in a meeting for 2 months ago, and I don't have notes of that meeting, I honest to God don't remember. So getting older is a very good thing for an expert witness. But anyway, so review all the notes of the meetings. If notes aren't included, some of these, I want to call them less experienced experts think, I'll be done in about 3 minutes here. Well, you're timing me for an hour?
No.
You close? Yeah, I'm just going to do an hour. Let's see, where was I? Oh yeah, so they think they're pretty cool and they know these notes aren't privileged, so they throw them out. Really? I'm not a cross-examining lawyer, but I would love to cross-examine the expert who threw out his notes after the meeting or says he doesn't take notes because he knows they're privileged and he has to produce them. Oh, really? You have a perfect memory? I mean, you guys ought to be able to ask 25 great questions to embarrass that person. But destroying notes or saying you don't take them is just unbelievable to me. Even if it's true, you ought to be able to make some great mileage on that in cross-examination. So the two-way street, I said this earlier, just be very passive in your examining. A couple other points. These are maybe minor or not. Don't give any information in your question. Please appreciate when some expert, and there are many of us who are running 50 and 75 cases, and we're going to the oral exam, the oral midterm exam, and I got 50 cases. There's a lot of stuff I don't know. And I'm just trying to cover the tops of the bases. So if you give information in your question, you simply educate me, and you might be surprised at how little the expert knows. Example, you're trying to do a nice transition. You're aware that the company has a cash flow forecast for 2018, correct? No, don't ask me that. I mean, you just told me that the company has a cash flow forecast for 2018. I might be saying to myself, damn, I know they have one, but I don't know if it's for 17, 18, or 19, and I don't know which one has the problem. So ask me, is there a cash flow forecast? Who made it? What does it say? Is it reliable? In other words, don't give me that information in the transitional question. Here's another one. I don't know what you can really do with this, but ask for opinions that are outside of the expert's area of expertise. Is the conclusion of the expert that you're relying on, for instance, in my case, it will often be a voc rehab person, is the conclusion of Dr. Hall reasonable? Well, I know enough to say, I don't know. He's a vocational rehab guy. I don't have anything to do. I take his stuff and I quantify it, but I don't know if it's reasonable. But remember, I've been getting beat up, or the average expert has been getting beaten up by his average lawyer for the last 4 months, that Dr. Hall says this guy's going to be able to be an orthopedic surgeon again, and man, has he done that? And so many times the expert will answer a question outside of his area, and I believe you ought to be able to cross-examine the expert on saying, you got no business in answering that question. Or it's another one, this is me personally, they'll often ask, do you know the reputation of Mr. Wallace, the opposing expert in this case? So, yeah. What do you think of him or his reputation? I'm not going to answer that question. Most experts, I think, the 40-year-old expert probably will answer it. I'm not going to answer it because I'm not an expert in reputations. Sure, I've heard of this. I mean, I really do know the guy. I've heard of this guy, but I don't have a professional opinion that I'm going to put on the record that is, talks about his reputation. And I tell experts that I'm talking to, why do that? It's a no-win, because if you say Bob Wallace is a great guy, you're going to see that as Exhibit 2 in trial. If you say he's an idiot, you're never going to hear it again. So why answer that question? It's outside of your area of expertise. So I think, one last thing. So getting the notes of the other experts. The best notes that you can ever get, if you can figure out how to get them. So you're defending your expert in a deposition. The lawyer on the other side has his or her expert sitting there. That expert is sitting there furiously writing notes and saying, this guy's an idiot, he shouldn't do this, he shouldn't do that, this is crazy. If you can figure out how to get those notes, I think that's a very fertile area. And now you use your legal skills to figure out how to do it. I think the way to do it is for you to stand up and say, gee, I noticed Mr. Smith has been taking notes during this deposition. Those are notes that are part of this. Of course, if he was smart enough to give them to his lawyer, good luck. But if you catch him before he gives them to his lawyer and you say, I notice you're taking notes, I would like you to preserve those notes because I'm taking your deposition next week and I expect a copy of those notes. You ought to be able to get them. I don't know. Now, if you're dealing with a crook and he goes home and changes the notes, I don't know how to do that. I don't do that. I don't think you should.
Brian Peter Brennig is an adjunct professor at the University of San Diego School of Law and managing director of the forensic consulting group of CBIZ, a national financial services firm. The strategies and tactics presented in this video presentation are discussed in complete detail in his treatise, Mastering the Art of Expert Witness Testimony, which is available by scanning the QR code on the screen or on Amazon.